All right, we're going to go ahead and get started. Appreciate everybody coming out. Want to acknowledge that we've got 5 of our planning board members, Joe Maynard, Lisa Miller, Phil Humbard, Lauren Shackelford, and Jay Piercy. Also notice that we have several of our JPs in attendance tonight as well. So just to kick this off, my name is Brian Lester. I'm the county attorney. A lot of you know Sam Atta. He's our director of our planning department. We've been working on, we as the county has been working at and looking at redoing our planning code for probably at least the last 6-7 years. We have seen over time a lot of problems with what we have. And so we've worked with regional planning. Jeff Hawkins was a big part of this, who helped us draft a lot of this, this new code to kind of alleviate some of the problems that he saw back in the 2006, in the time that the planning was passed. He had a lot of concerns that were ignored, and it kind of led us to where we are. So with that being said, pursuant to the law, we are having this meeting. The planning board's here. We notified the school boards so that anybody that, any school administrators or school boards could attend. We're going to have just a pretty general Q&A, answer as many questions as we can or take any comments that anybody may have. And so if you are interested in asking a question or making a comment, if you would come to the podium and give us your name so we can make sure that we make note of that. And with that, I'm going to go ahead and turn it over and invite people to come up and speak and ask questions. So, I mean, if everybody came here just to hear what everybody else said, that's fine too. I'm good with that, but if you have a question or a concern or a comment, planning board as well, if you have any questions, you know, now's the time for us to look into that. Hold on a sec. If you would turn there you go. There
Dinah
you go.
Dickerson, live out on Greenboro Road. Can someone actually just give us an overview?
Sure. I'll be happy to do that.
I think most of us are just in the educational stage at this point.
Absolutely.
Thanks.
So the big change with this is going to a more conventional zoning. What we have now is a hit or miss request for a permit, and you know, there's no rhyme or reason why some projects get approved and others don't. It's very just all over the board, it seems like. It's just kind of one of those things. That's the process that we have. And so what we're looking to do is to go to a more conventional zoning and not a very complicated zoning. You know, cities have a lot of really complicated zoning. The counties don't. We don't want complicated zoning, but we do want zoning in a way that will protect individual property owners, protect business owners, and just protect the county in general. And so what we've looked at doing is implementing this new zoning. We'll have 3 different zones. We'll have residential, which includes agricultural, which is what everything is pretty much de facto zoned now. We'll have a commercial, which includes 2 different types of commercial based on the use. And then we have an industrial. And those are our 3 different zones. In this new, in this new scheme that we've got, there's actually a list that kind of lays out, you know, based on the business, what you are, where you can go as a matter of right, and then where you can go with conditions. And so there still will be some conditions, but the way we're going to look at this is we're going to actually start with the zoning part first. One of the things I think I'll start by saying that kind of started bothering us when we looked at this is several years ago, we had a group that came forward who wanted to build a recreational center out in the county. It was outside the city limits of any city. It was kind of between a couple of cities, but they wanted to build a gym for that. And this couple had saved up. They'd done their research, and they'd spent a lot of money. And they worked really hard, and they worked with the planning board. And the planning board said, hey, address these issues, address these things, address parking. The neighbors had come forward. It was out in the middle of a cow pasture, and needless to say, they made all the changes, did all the things they were asked just to get to the planning board or the quorum court, and then we have some other people came in. Needless to say, it got denied. These people didn't have the money to appeal that to the circuit court, and they had done everything that had been asked of them. And so that really kind of didn't sit well with a lot of people. And so a lot of that had to do with the fact that we couldn't really give them an answer on why it was. And so we've seen that happen a lot of different times. And we understand that as a property owner, you move out to the county. Most people move out to the county, buy land in the county because they want that more rural setting. And fair enough, we should be protecting that. But we also understand that as we grow in Northwest Arkansas, we are going to see more business, more commercial, more industrial. We know that in order for us to continue to grow, we've got to have certain things for infrastructure. And so we want to make sure that we are able to protect the rural parts of the county, protect farms and farmlands, but also have a place that we can direct commercial business to go. So that it's not just popped up out in the middle of nowhere in the county, which then oftentimes doesn't sit well with the neighbors and the property owners. And so this is our attempt to really consider what's best for everybody involved. Applicants, neighbors, the county itself. I mean, this is really what we want to get to. And so what we're looking to do with this new scheme is the first thing we'll start off with is zoning. People that want to come in, if they want to come in and they want a business in the county and it's not already zoned, the first thing they're going to have to do is they're going to have to ask for the quorum court to change the zoning of a piece of property. We have a list and some things for the quorum court to look at to make a determination as to whether or not they'll change that property designation to allow it. They don't have to go any further than that. If they don't get the zoning change that they want, then they're done. That's over. I'm sure they can appeal it. That's certainly something that can be appealed to the circuit court, but at least they're not already 90% through the development of their project when they find out the answer is no. And so that helps applicants, but at the same time, it helps neighbors know that once it ends there on the front end, it's over, and there's nothing else to do. And so these are kind of the things that we hope will happen with this new planning code to kind of address some of the issues and some of the hang-ups that we've seen and we've heard from our constituents in the county over the years. And that's really the big change. Everything else in this is the same code that we've had. We've done some cleanups, we had some redundancies and some things like that, but that big main change is just that zoning aspect. So the process will be, you would come forward, you would request a zoning change. If the zoning change is permitted, or you come forward and want to do something and the planning department says, okay, it's already, where you're wanting to do this is already zoned appropriately, that checkbox is done, there's no need to rezone. We start with the development phase, working through the planning team that eventually gets approved by our planning board. They add conditions, they make sure that certain aspects are being addressed appropriately, and once that's approved, then the project moves forward. If someone comes forward and they want to change zoning, if the zoning changes, then it continues to move in that process. So the legislative part of this is kind of on the front end, which is the heaviest of all the lifting that goes on. What we have now puts that legislative process at the end, which is what costs so much money to get to, only to find out that you can't do what you've sunk a lot of money into. And so we're changing that up a little bit so that we can tell people, hey, nope, that's not going to work there. Go find some property that's zoned or something that's in a better area. You can always come back and request something different. We had this happen recently with a wedding venue where it was denied by the quorum court, and the applicant went, and after some diligent work, several months later, she recently has come back to the quorum court. She found a spot that actually worked. It was actually in a good spot for a commercial venue. There were no issues, and it was approved by the quorum court. That's what we want to see go on with the way we do zoning, is that people can be told, they find out that it's not going to work, they can go try to find somewhere else that will work, they come back, then we can see if that project is approved and continue the process to help the growth, but also to help neighbors. So that's a big nutshell. Joe, turn your mic on, please.
Make sure I understand what you're saying there is if someone is in the middle of a rural area today they would ask for a CUP, come to the planning board to build a cement factory in the middle of a hayfield. They would have to go to CUP and then it be approved by the planning and then be approved by the quorum court. That's how it is today, correct?
Yes.
Correct.
Okay, the way it will be after this would be, they would go to the quorum court and ask to get that piece of land zoned differently.
Correct.
Zoned commercial and based on the use.
Yeah, all the control goes to the quorum court on what you can do with your land, essentially, right?
No, the zoning it's already with the quorum court. Zoning is already rests solely with the quorum court.
Well,
That's a
you're creating
legislative
zoning
function,
that will be subject to the whims of the quorum court.
like it is now. Yes.
Right, but if there's no zoning, you do a CUP, and you don't have to get it zoned differently, right?
Eventually, it needs to be ratified as a use for commercial. So
Yeah, I
that's what
understand
we
all
do
that.
right now.
Yeah, I get it.
Yeah, you can attempt to get a CUP, sure.
Right.
You can ask for one.
So what would be the purpose of the planning board then?
Well, the planning board still has to approve the conditions and stuff to approve the project and the design. Same thing that all planning departments do. It's the zoning
Okay.
part that has to be approved by the quorum court.
Yeah, I was unaware we approved designs, but that's okay. I got my question answered, thank you.
You're welcome. Any other questions?
Alan Langford, County Road 662. So I guess I have a few questions. One of them kind of answers yours. If someone comes and wants to put in a dirt pit on your road and they're denied a cut by the quorum court and they appeal it and they go to circuit court where they're also denied, it appears they can continue to operate illegally with no restriction. Because at least that's what happens on our road.
What road is that?
It's County Road 662,
Was that the
Heritage Farms.
Heritage Farms?
Uh-huh.
So we were removing that provision in this new code. There's a provision that was passed back in 2006 or 2007 that says, there's an ordinance that says, once an appeal's been filed, the county no longer can enforce the ordinance through like the sheriff's office, through a fine or anything like that, which means that the only enforcement mechanism then goes through the circuit court, and you have to ask the court for an injunction. And so the way injunctions work in Arkansas, in order to ask for an injunction, you have to be willing to put up a bond to pay for the money that could be lost that someone has on a property. So that could be $10, $15, $20 million, depending on the length of that project. And so once we get to that point, there's a statute that says we can no longer enforce that. Now, this new code has that removed. So we can go out, and as long as somebody is operating, even during an appeal, they can be fined up to $1,000 a day for operating illegally. $1,000 is the maximum limit that a quorum court has that it can put on a fine. That's why the limit is $1,000. But we have gone in and made those changes so that we're not limited by that anymore. Absolutely.
So right now, there's still nothing that can be done? even
Until
though it's-
till we change the code, till we change the law, there's
Even
nothing
though
that
it's
can be
no
done.
longer under appeal?
The Bobby Morse is
Yeah.
still under appeal.
Okay, I mean, I've called the state capitol, nobody can see where it's even on the docket to be heard by the Court of
I
Appeals.
can tell you there was a brief filed on the neighbors. I think, Dinah, are you a neighbor? Are you on that? Mr., yeah, are you one of them also? Ross refiled a brief. Something happened with that, with the Court of Appeals that took us reaching out to the Supreme Court and saying, hey, what's going on here? But that somehow got off track. It's back on track. A brief was refiled recently, and so that is moving forward.
Okay, so then my next question is, and I'm not a lawyer.
Sure.
But when I read through this, it seems like Agri is pretty well protected. So if he wanted to continue to operate this under the guise that, hey, I'm going to put in a greenhouse or I'm going to, run cattle here, does that mean he can continue to operate and do what he's doing if he says, hey, this is what I'm going to do?
No, it's based on the use. I mean, that's one of these areas that the county has to consider what the landowner is doing, and has to know that if it's an agricultural use, that's what's actually being done.
Okay, all right, thank you.
Is it
Amen.
Shannon Weathers, Springdale. Address is Heritage Farms is properly permitted through ADEQ, and I know there's other things that go into that. But what I want to ask is, on your zoning, what happens to, like that one, for instance, it doesn't fall into that particular zone, or if a guy's got a manufacturing business currently and it doesn't fall into the zone that you have, what happens then?
So if they've already been approved for a CUP, that zoning will be updated on our zoning map that has to accommodate or accompany this ordinance. And so all of those projects, Sam's actually gone in and looked at every one of those CUP projects since zoning came out, and has changed. In the new map, it will change that designation. So that will be zoned, however, whatever that CUP is, will determine what the zone of that property is.
If the use stays the same.
Okay, well, let me give you another scenario. Guy's got a shop in his backyard. He starts painting cars for his own self, and neighbor wants to have a car painted, and next thing you know, he's got a pretty good business going. Or a lawn care business. Guy starts with because I've gone in front of Benton County on behalf of one of my clients. He started out with a lawnmower and a pickup. Well, it grew to 4 or 5 lawnmowers. He'd been there since '91, and he gets 6, 7 people. Well, now he wants to build a 1,500 square foot shop, okay? Mainly to put his RV in, boat in, and then he'd have a little maintenance stall for when they need to change oil and stuff. A person moves down here from Illinois. She complains that she doesn't like that. He's been there since '91. She moves in 6 months ago, and she complains to the planning commission. And the planning commission denies him a permit to build this house, to build this shop. That's not right, guys. As long as that building meets the design criteria of the planning commission. And he started his business, and so he didn't have a CUP or anything like that, because this is in '91. That was before the rule was even in. Just
Right.
like here, there was stuff done before the CUP. I was born and raised in Washington County, and I don't like what I see in those type of things. So that's why I'm bringing it up.
Sure. You know, again, any use that has been in existence, a non-conforming use that was in existence prior to 2006 is grandfathered in. We have tried to.
2006 is the year.
2006 is when the first planning ordinance was passed, when zoning actually came into the county. We've had planning, but zoning actually came into the county in 2006.
Okay.
That's when everything was zoned single-family residential / agricultural. Any non-conforming use that was in existence at that time, as it currently is grandfathered in and doesn't require a conditional use permit. Sam has worked on that as well to make sure that we are accommodating for that. I can't guarantee.
Great.
I can't guarantee
me and
that
him,
this is all
we
going to
get
be.
along.
I'm sorry.
I said Sam and I get along
Sure.
just fine.
So we have tried to address those as well. And I can't. I'm not going to have all the answers based on all the scenarios. There will be things that the quorum court will have to address from time to time as we continue to see an increased growth. But that is all things that the quorum court will still be able to make changes and modify once those things come up.
Okay. Well, see, my clients, I help them get permitted through ADQ. And that goes through a legal notice in the paper, 2 legal notices in the paper, for instance, like Heritage Farms, where anybody can comment
Right.
to the state. Nobody did, and he got a permit.
You have to understand too that those permits are completely separate from the local permit, and ADQ will even tell you
I know,
that
but
if you're operating
there's only
illegally.
2 counties in the whole state of Arkansas that require these CUPs, and it's right here, Benton and Washington County. It's not anywhere else in the state.
I agree. There may be one more, but I agree with you.
Yes.
The problem is we're here, and there's no way to take it all back. So we've got to make do the best that we can with what we have, and that's what we're trying to do.
Okay.
I think there's a lot of people that would tell you to go back and redo this. We wouldn't have done it the way we did. We wouldn't have done it at all.
Okay.
We're
Well,
well
I
be-
just,
we're well beyond
what I
that.
do is a client like that, they spend a lot of money in engineering, a lot of money in permits, and they have a lot of hoops to go through for state level. And to have another level to go through, you know, I just want to be able to guide my clients correctly.
If your client is the, is the person I'm thinking who is, we received also like plans for the engineer, for an engineering company that says he is leveling off the land to use it for agricultural use. So we're getting two different stories,
Well,
and that was recent.
His end result is going to be lowering that down to where he is going to use it for agriculture. So the end result of that project is going to be agriculture. He just wants to lower that. And that's what he's told the state. That's what he's written. So,
Thank you.
anyway, thank you.
We have the continuous of use, so that's.
Jerry Napier, what is a conditional use permit?
What is a conditional use permit?
Just that after the zoning, you can do whatever.
There will be no conditional use permits with the zoning. We'll do away with conditional use permits as they stand right now is a permit to you for a non-conforming use. A permit that allows you to use your property for something other than single-family residential or agricultural.
Okay.
And so that is a conditional use. It's a permit to operate a non-conforming use. There are some ramifications to that. It attaches to the land, but that's really what a conditional use permit is. It's saying conditionally you can do this with your property.
Okay. Thank you.
All right, you're welcome.
Hi, my name is Lee Turner, and I understand the three zones, the residential, commercial, industrial. With the new ordinance, have there been changes to those new zones? Are there multi-use zones, for example? Have they gotten bigger or smaller? I assume that you have a map with those that the public would like to see.
Yes, we have a map that's on the county's website that the public can see. Those zones have not changed since they first came out. We've made some small technical changes on some of the things since this first came out, but those zones are all the same. The way our zones work is if you have a zone and it lays this out in there, if even these zones that will be as designated as commercial that are currently not being used, residential and agricultural are still allowed in that zone. So that allows, that doesn't require that it only be used for a commercial purpose. You can still use those for residential or agricultural up to commercial. But the chart that we have kind of lays out what can be done and what can't be done in those zones.
And it's also based on the size and the use, the type of use, and the setbacks of the lot itself. So you cannot have an industrial on like 5 acres, for instance. You don't have like the space or the setbacks. So it has to be a minimum of that size of land. So if you go to the website right now, like to our web map, you're gonna see all the CUPs that all gonna transfer to become commercial automatically because they're already been approved. You're gonna see commercial use, potential commercial use. There is no breakdown for like commercial 1, commercial 2, commercial or industrial yet, because we don't have that zoning. Once we start have like assigning or designating this project to become like a C1 or C2 or industrial, it's gonna change. So that's when you go and see the breakdown of each one of them.
Okay.
Yep.
Thank you.
Dan Smith, I live in Springdale, out in the county. Couple questions. Actually, first one is this going before a vote tonight, or is this a work session, or what's the process?
Just public hearing.
Just
Has
public hearing.
There's no vote tonight.
So there will be another one of these before a vote, or?
This will go to the quorum court at their next meeting next month.
Okay. And on the map, I saw, I mean, so basically, when you look at the map, we don't have it up right now, but it's got commercial basically on the main roads.
Correct.
Basically, right?
Right.
Has there been any consideration on maybe focusing commercial kind of at those intersection, as in nodes versus everything on the commercial, everything along the main roads being commercial?
We kept all like the to be zoned out of the city limits. That's like the first thing.
Right.
So everything is outside the city limits. We went 300 feet out of those like main corridors. We eliminated everything that's state, federal, or like subdivision, because most subdivisions, they have their own covenants, so we don't want to like get into that. Other than that, is if you have a house there on one of them, you don't have to change the use. Even if it's automatically become commercial, it doesn't have to affect you. Taxes is not going to change. Taxes is based on like the use. You can always like go and sell it as commercial and like get more money for your house, but it's not going to affect you if you stay on it.
Yeah, understood. And it's more from a planning perspective, is that one to see if, you know, there might be some use to concentrating commercial uses toward major road intersections versus just literally spreading them all over the county.
And that's certainly something the Quorum Court could consider. The plan we put forward was to look at those main corridors so that we would have zones, which is required. We've got to have a place for that growth to go, and so we just use those main corridors. We get into a lot of questions about, well, what's a major intersection? What's a minor intersection? We try to just keep it pretty simple, but that's certainly something the Quorum Court can consider when they look at this.
Couple other questions is, obviously there's no sewer in most of the areas we're talking about, so residential density won't be 15, 20 units per acre like with a garden-style apartment complex. But within the residential, actually in commercial, because even commercial, you said would allow residential as well?
Correct.
So what kind of density is allowed within commercial and residential in terms of units per acre?
It's like we still have like for residential, like 1 house per acre. So if you have 10 acres, you can technically build like 10 homes on it. But of course, with the setbacks and everything, when it comes to septic or anything like sanitary, is like controlled by the state.
Yeah,
so
understood.
there is nothing we can do about this. So you have to go about like satisfying all the codes that the state or the federal government has, and then like the planning will kick in. So the density, like I don't think like it's going to be ideal for someone to have a factory and then like build like a couple of like homes next to it. It might be a hotel, for instance, or like a wedding venue, and they might have like a couple of like Airbnb or like for rent. So like if you have an event late night, you can live in it. So it's definitely going to be something that complement that like.
So for example, let's say I can get a septic approved for a triplex, fourplex, whatever, for a 3 or 4 acre site. You know, I guess technically that'd still be one per acre, but something more dense than that would be allowed.
The state like would require you to have the septic designed based on how many rooms on that building.
Right.
So if it's like 5 bedroom, they're designed it for that. If you're going to improve on it, add like 2 more, you have to go back to the state and get like the approval and the septic like redesigned for that to accommodate for how many rooms you have.
Okay, I think I'm hearing, understanding, is that the septic will drive the density, basically. Is that, am I understanding
It's
right?
it's based on the requirement, how many rooms, how many septic like size you're
Right.
gonna have,
Okay.
And that's happening right now. We have lots of people coming in and says, I have 2 bedrooms, I'm gonna expand on it, so what do I need to do? You don't need a permit from us right now, but you have to check with the health department because there's gonna be lots of requirements that you have to go through with the state.
Yeah, I'm thinking along terms of, you know, affordable housing, trying to provide more housing and increasing density. And then the last thing, so anything outside of the pink areas on the map that somebody wanted to do something else with would still go through the CUP process, is that right? It would have to get rezoned,
I don't know what's the pink area.
which is slightly different than the CUP process, but similar?
Correct. It would have to be anything, any change like that outside of these zones would have to be rezoned to do something other than just single-family residential or agricultural.
And how is that process going to be different than the CUP process? Is it very similar? Identical?
It's somewhat similar. The zoning part happens at the beginning.
Right.
And so the first thing that would happen would you'd have to be approved for a rezone before you could move forward with your project at all. Once approved, then it would go through the planning department, the technical provisions that we require, and then it would require approval by the planning board as well.
Okay. That's it. Thank you.
You're welcome.
Can I piggyback on that?
Sure.
Because that's a couple of questions I had. So the rezoning would create use by right, which would give some clarity to the applicant. Is that correct?
Correct. Yes,
Okay. And then looking at this, the majority of what we're proposing for commercial is, again, what he talked about, creating commercial nodes, commercial corridors. I know you can't speak for the quorum court, but the process of rezoning out there, is that something that this is addressing as well? Try to not have as much spot rezoning, as much, have more clarity with where we want those? Are we still gonna, you think, see a lot of spot zoning requests, and how do you think the quorum court will handle those?
I mean, I think the quorum court's gonna have to be, recognize that, spot zoning's illegal. And so there's a lot of reason not to allow spot zoning out in the county, and this helps drive that commercial business to these corridors to say this is where we can allow, where we'll allow things to go. I mean, my thought is it's gonna be very difficult, if not almost impossible, to take and just put a commercial or industrial site right in the middle of nothing, where there's nothing close by. There are certainly things to take into consideration in proximity to proximity to a commercially zoned property that changes that a little bit. But as far as just right out in the middle of nothing, then that's going to be very difficult for an applicant. You're welcome.
Do we have to give her name or just ask the question?
State your name.
Sherry Main, 15451 Ridges Road, Fayetteville. I have a lot of questions, but I won't take up everyone's time asking them all. On one part I don't understand is what it means by, on page 10, it says, quorum court desires that building contractors acting as a consultant be included in professional services that do not require competitive bidding. What does that mean?
That has to do with, that doesn't really have much to do with the planning. That has more to do with, this was part of what had already been codified in our plan. The quorum court passed an ordinance years ago as it can do as it relates to competitive building on certain things, and that's a thing they've exempted from competitive building.
Okay, so, but that's in the
Right, because
very beginning language on, in general, and then it goes on to say the procurement of professional services, and then it reads all of that.
Right.
I just wanted to make sure that that only applied to professionals applying for a cup.
No, this has to do with professional services, the things the county has to use competitive bidding for. We can't make people in the county use competitive bidding for anything. We as a government have competitive bidding.
Okay, it doesn't change the county then itself still has to do competitive bidding.
Yes,
Okay.
and it's the way it's been for 30, 40, 50 years since they passed it.
I had a lot of people ask me that question. I just wanted to make sure that had not changed. On the conditional uses, if you go to quorum court, if your property is not properly zoned under the new proposed zoning, you're going to go to the planning administrator and you're going to say, fill out the paperwork with the planning administrator, which is the planning director currently, Sam.
Currently.
So he's going to do the paperwork to apply for the zoning to be approved for the quorum court, and he's going to get it on the calendar for the quorum court meeting to have just the zoning change. Since that's just a legislative act, the quorum court is only going to do zoning changes. If it's not already in the C1, C2, all of those, then it has to go to the quorum court to get a zoning change.
Correct. That request will be made through the planning department, and then the planning department will notify the county judge, who will then get it on to a quorum court meeting with the requisite notice being provided. Yes.
Okay.
Just like an appeal's done now.
And if that is approved from the quorum court, just that there's no conditions or anything on anything at that point, it's just a change of zoning.
That's correct.
If it's not in what already qualifies, then it'll be considered by the quorum court as a legislative action on the zoning use only. And that if they deny it, that appeal then would have to go to circuit court.
Correct.
Okay, so there's no other alternative for appeal from the applicant or the other parties except circuit court on that
Just like
zoning
it is
appeal.
now. Correct.
Okay. Let's say, for instance, it's approved.
Okay.
And then it goes back to the planning board. The zoning now is characterized as correct, and so it goes back to the planning board, and it goes through those steps, the 5 steps that the planning board has to go through according to the new rules, which it has to have a plat, it has to have all of the information.
That's what we do right now.
Right.
So like we have to go through the tech review and everything.
And then it would have conditions put on it by the planning board.
Yeah, approval
Okay.
conditions, yes.
And in that meeting of the planning board to issue the CUP, the conditional use permit,
There is no CUP. It's supposed to be approval condition. If it says like CUP, it might be the copy that like we had with the mistakes because we had some updates to the website. But yeah, there shouldn't be a conditions as much as conditional for approval, not conditional use.
right, but a conditional use still has to be approved by the planning department
No.
for, well, that's what it says in here.
Which
That's
page
why
is
I'm
it?
confused.
Which page?
In conditional uses,
Which page, ma'am?
this is section, on page 102.
102.
Conditional uses starts with G, number 1. Says name and description, certain uses may or may not be appropriately located within various districts due to their unusual or unique characteristics of operation and external effects, given their unique character, analysis, and and operation. Given under character, analysis, and judgment of the consequences of each development and use must be given as to provide for each reasonable condition and protection restrictions as we deem necessary to protect the character and integrity of the area in which uses are proposed to be located. Such uses are listed under the various districts herein as conditional uses and may be located in the district or districts so designated only in accordance with the procedure described herein. That's if you fit the criteria under P.
Right, so
If
some
it's a
uses are
C-
permitted as a matter of right, and some are
If it-
permitted with certain
If it's
conditions.
a C in any of those, C1, C2, whatever, I know industrial zones all have to have a cup. They
No.
have
If it's
high
outside the
intensity industrial zones.
everything needs a condition.
Have you looked at the chart, Sherry? Because you'll notice that not every industrial has to have a cup. If you just read the chart, it'll tell you what does and what
But
doesn't.
how would you put conditions on it?
Do what now?
How would you put conditions on it without a
Well,
cup?
some things you don't require conditions in an industrial project. In an industrial zone.
Well, industrial zoning in here, though, a lot of things could qualify in an industrial zone. An asphalt plant, a lot of stuff. And I don't know how that's gonna not change the shape or integrity of the property around it.
Yeah, but there are some things like a service station or a school or a restaurant. Those are permitted as a matter of right, don't need conditions.
But those should be in a C1 or a C2. They
No.
shouldn't be in industrial.
We'll make note of that. We appreciate your comment. But that's your thought, but that's not how Jeff Hawkins worked with us on drafting this.
Well, that's what I'm saying. It's not clear in reading it, because I've read this thing forward, backwards, and highlighted yellow, green, purple, blue, whatever color you can get on here. And everything I'm reading, it goes back to the conditional use permits. It says the procedure for authorizing is the following procedure is established to integrate properly the conditional use with other land uses located in the district. These uses shall be reviewed and authorized or rejected under the following procedure. And then it goes on to tell you how the application it's filed with the zoning official. You know, I mean, it goes on to tell you the steps, 1, 2, 3, 4, 5. And then upon determining that an application is proper and complete, the zoning official shall ensure the matter is set for public hearing before the planning board. And then the notice of the days, the 14 days, and all of that notice now falls on the applicant to send by certified mail. It's no longer the planning director's responsibility or the planning staff to send out those registered letters. They have to give a list and proof that they sent them out certified 14 days prior to the meeting.
So we normally, like, even we do that for the applicants, but like we charge the applicant for it with extra like fees for like services.
Right.
So, and that is like way time consuming than you think. For instance, we have 14 projects this cycle, and we have more than 200 like mailings that they have to go out. That is like a lot. That is like about like a week worth of work. So with a department as small as ours, we're gonna like either like work on a weekend, which sometimes we do, or we have to make sure that the applicant is responsible for it. And by the way, Washington County is the only one in the state is doing that. Everyone else just like ask the applicant. They gave them like a note, they sign on it, we provide all the information, they send it, provide the proof that's already went out, and we take them to the board. If that does not meet that date of the resubmittal, we'll see you next cycle. So
Okay.
It's just like that standard. That's what's been happening forever.
Right.
Yep.
And you provide the map with them of the 300 people?
Yeah,
of
we
the
provide
300
like the
people
list. We're
with
gonna
all
make
of
it
the
easy. We're gonna give
addresses.
you the list with like that needs to go out for how many people. Yep.
And on the other qualifications for a half a mile, you would also provide
It's
that?
the same thing. It's like
Okay,
like area of notification doesn't
For
change.
the half a mile notification
Yep.
period?
Yep.
Okay. Another question I have is, it seems like this is going to place a big hardship on the planning department. I know the staff is small there, and Sam pretty much is the chief cook, bottle washer, does it all. And the county judge is going to appoint the planning administrator. The planning administrator has to do all the enforcement, take all the complaints, write up reports from the complaints, follow up on those complaints, whether or not they're merited or not. That's going to take a lot of time. And I don't see how Sam can do any more than what he's doing. And I don't know if there's been any mention of having another staff member. If there's going to need to be another staff member, we're going to have to allow budgeting for that, because I think that's a job within itself right there, is just the planning administrator. The planning director has his own task, his own things, and that's a lot. And Sam's already doing that, and this is going to put more work on him with already a very small staff. So I think that needs to be looked into about possibly a planning administrator besides what's already in the planning staff. And you might note on page 3 in general, it references back to line 32 and 34, the development plan, and it's duplicated. There's two different meanings for a development plan on 32 and 34.
Pages 32 and 34.
That's page 3 of the general, yeah. And it, because I kept referencing back, and I don't understand which one I'm supposed to reference to, so. All right, I
Thank
may
you.
have more questions, but thanks, that's all.
Appreciate that.
That's different.
Dinah Dickerson again. A couple of questions. So how will the rezoning process, I think you talked about it, they come to quorum court to ask for rezoning, and if it passes, good. If it does pass, what's the public's right to do an appeal, or then what?
The public still has a right, just like you would the passage of a conditional use permit now. The public has a right to appeal a zoning decision to the circuit court. I mean, so there's still an appeal
You gotta go
process.
straight to circuit court.
Right, because that's a legislative act, and it can only go to a legislative act can only be appealed to the circuit court under the arbitrary, capricious, and unreasonable standard.
Okay, okay. And, hang on, I've just got a list here. And you said something earlier about if they have a cup, that'll be grandfathered in to the zoning. And if someone's been denied a cup, is that also gonna be grandfathered into the zoning?
Well, no, it won't be rezoned. I mean, the grandfathering in is we will zone that property based on the conditional use permit that's been granted.
now.
If
Yeah.
not, it'll just stay as
Well, the
residential.
meaning so we don't have to go back through, if we've already gone through that fight to,
Well, there's no, and you know, I'll make this clear, nothing prevents someone from requesting a conditional use even after they've been denied, re-requesting one.
Yep.
Just like with zoning, you know, nothing would prevent someone later from requesting a rezoning of a piece of property that was once denied.
Yeah, adjust like maybe to a new project and reapply. Yeah.
understand. And so for the 3 zoning areas, you haven't done that yet? I was just looking at the pink lines, but are the 3 zoning areas actually established already?
Yes, the projects that are already in use, the conditional use permits that have already been approved, and projects that were grandfathered in, we have, on this map, you won't see it, because this was really to show the corridors and the commercial, but if you look at the actual map that you can zoom into on the county's website, you can see those properties that we already designate as being zoned something different than residential.
Okay, and is there more to come on those 3 zones? Or are you still going through a process, or that's kind of this is what?
This is what we've got now. Now, the quorum court over the years can change this and add more zoning if they want to, but this is our starting point. This is what we're looking to start with.
I don't know if you're driving. Can you pull that up or tell us where that is? I was just trying to do a quick.
The zoning map?
Yeah,
So
that
if
one
you
you're
go
talking about.
if you go to the county's website and you go to go to government, go to planning, on their website, there will be a link for you to click onto the map that's interactive.
Okay.
And Sam's gonna pull that up and show you exactly.
Okay, because I haven't seen it. And so that, you guys have already done your due diligence, and here's the 3 zones
That's correct.
that you're gonna propose?
That's correct.
Okay, so we can go check.
That's right.
What's there. All right.
Because we had some things based on the algorithm that he ran that we needed to change. You know, we can't zone national forest. We're not gonna change the zoning of a subdivision. That's all done by the computer based on an algorithm. So we've manually gone in when people have asked about it to make those changes, because that's not our intent.
Okay. And then I think a lot of us are interested in this. So if it was starting over and somebody was coming in for a red dirt pit, how would that process work?
They would come and they would ask the quorum court to rezone it as an industrial zone. And they would make their request and their case to the quorum court, and the quorum court would make a determination whether or not to rezone that.
And is that it's an application, there's a whole, you guys are doing a bunch of study? I mean, when we went through Heritage Farms, right, through all that process, there was a lot of paperwork and a lot of, I guess, research done and shared for people to weigh in to figure out if that, so how's that gonna work with the quorum court?
It'll be an application. I mean, it'll be an application like you see and like you see anywhere else. I mean, it's just a request to rezone, to say, this is the zone I'm wanting to change this to.
And then in the red dirt example, what's the quorum court, what are they gonna do to see if that's an okay rezoning?
Well, they'll look at the zone, they'll look at where it's located. They'll look at how, they've got to look at where that's located, the zoning that's around it, and whether or not that's a compatible zoning, if that fits in that area. And that's what the quorum court will make the determination on.
And to further that example, in our case, it would have been normal agricultural homes zoning, But then you always get into that, oh, but 5 miles from here, years ago, there was a dirt pit. And so is that going to weigh in? Because that's
that-
kind
all
of the
those-
kiss of death for all of us in the county. You go 5 miles somewhere, you find another dirt pit.
There is no cut and dry answer of this is how close something has to be. I mean, those are all things that the legislative branch gets to consider when approving or denying a zoning change.
This is why we're gonna have an application for zoning, and this is why the neighbors, they're gonna be notified. So, yep.
And is that notification distance the same? And if somebody
Yes.
else wants to come up, come on up.
Yes.
Is that the same distance
Yes.
as it would be today?
If it's like industrial or like high intensity, it's like half a mile. There is no reason to change it. Yep.
Okay. And then on that same zoning, is that a reading at the quorum court? And you go through 3 readings and the public comes and does their whole thing?
Yeah, it'll be
or
an ordinance, so it'll have to go through 3 readings.
Is that the standard legalese? Okay. Good for now, thanks.
Sherry Main, still on Richards Road, Fayetteville. I have another question that just come up from what she said. I put in my notes. On a large-scale development, it has to go through planning, and public comments are only going to be allowed at preliminary and final plat stage.
We've never done like public comments for like finals. It's always like the prelim only.
Well, that's what it says here.
Where?
On page 45 in G, public comments shall be taken prior to any decision by the planning board at the preliminary plat stage and the final plat stage. Approval of the preliminary and final plat shall not take place at the same meeting, and the approval of the final plat shall be no sooner than the next regularly scheduled meeting,
I guess I thought like we should.
because they have to do the certified mail half a mile within 30 days before the meeting.
You said page 43. I don't know which
It's-
copy do you
See,
have.
I printed off the first one, and then
Yeah,
the one
that's
that
the
was
first one
attached
is
to the agenda,
way being changed. So.
the last county services meeting, the one that you attached to the agenda, I can't compare it to this one that I first highlighted. I had to go through and highlight the new one because the pages don't line up.
Yeah, the one is posted right now. It's like the old one because the website is
Right.
being updated. So what you have is
Right.
different than what you read than what I have. So
But no, this reads the same in the new one.
okay.
I
What's the
have it
heading?
on my phone
What's the heading?
highlighted.
What's the
It has a
heading?
different page, but it's under the, let me find the heading it's under. It's under the large-scale development standards, which qualifies as under quarry mining, dirt pits, and gravel pits.
Oh, page
And, I mean, this, large-scale development standards, this shall include commercial land alteration by way of excavating, quarrying, mining, similar activities. It's not limited to dirt pits, gravel pits, quarries, asphalt plants, concrete and cement plants, and any other commercial operation that would generate heavy traffic, such as affected roads would require improvements, increased maintenance, present a danger to the public safety on said roads, but no event shall include a farm or other agricultural activity, nor shall it include a single-family residence. So it's hard to understand for a layperson to understand this without, and it's going to be the administrator's job to enforce, understand it, and explain it. I don't know if we're there yet. I don't know if we're there yet to wrap our heads around this. It's a lot. And I've been looking at these ordinances for the cups and all of this for 20 years. I've been following it back to Judge Hunton when we first got an ordinance. And I'm just not wrapping my head around it. So I don't understand how other people could possibly wrap their heads around it when it's not understandable and it doesn't read and it doesn't flow correctly and the references are kind of iffy and the procedures, I don't know. I'm just saying that it's a lot. It's a lot to take in, a lot to digest, and I don't know if anybody has read the whole thing through and through, highlighted it with 10 different colors with markers as to what affects what I have, and I can't make sense of it. So I'm just putting that out there saying we need some more understanding on it before we approve something. We didn't have a lot of understanding on the first one 20 years ago, but it was a start. And the para task force went through it with a fine-tooth comb before it was approved. And that took 1.5 years. And it wasn't as intense as this. So,
90% of this is exactly
sorry.
as it's been written in our code, and it hasn't changed, but thank you so much.
But we
Appreciate
can
that.
change this. I mean, but it's gonna,
Sure.
and we did change the one 20 years ago, but we don't want that. We don't want to have to automatically keep making it a mess and changes. Like, that's why we're having to update it now, because we have all these amendments and changes to what we have now. And we don't want that again. We don't want to repeat. So let's try to get it
Go
as
ahead,
right as it
go ahead,
can.
like, and email me the highlighted stuff and like we'll look it over.
Okay,
Promise you.
thank you.
Hi, Ines Pradella. I live in Weddington Woods, 16235 Walnut Trace. I have a question about who gets notified and the time frame that they have to respond to that. So the version I read, which I think is the most recent one, property owners within 300 feet of the exterior borders get notified. So it's a pretty short distance from the property. And there's a 14-day notification. Is that correct?
Yes, ma'am, and the 300 has been there like forever, and that's like business standard. So in the cities, they do 100 and 200 based on the density. In the county, we did like 300 because that's what like the utility mostly use. They use like 300 or 400, depends on which utility it is. If we're gonna do like more than 400, we're gonna include like lots of places in the city or like the planning area within like lots of larger areas. So 300 has always been the standard for the county and it hasn't changed. So 14 days, normally you notify as the applicant, or the notification goes out 14 days before that like meeting date. We normally, like when we send the neighbor notification right now, we'll give you like a minimum of like few days to respond to us. That is before we take it to the planning board. So we notify, we mentioned like in our application, Friday noon or like Monday noon, it depends on the project and like the dates we have. So 14 days, 2 weeks. When you send anything in certified mail or like regular mail, it gets there like within 2-3 days tops. Even with a holiday, it doesn't take that long. So you have enough, like 14 days, like 14 days, not like working days, 14 days to respond to us through emails. It's not that like, yeah.
So is that a change from the current process, or that's the same?
It's the same.
It's the same as the current process,
Yep.
okay.
And based on the project, is it like either half a mile notification or 300 feet notification?
Thank you.
Yep.
And then second question, then when that proposal comes to the quorum court, the time that's allowed for comment, so like tonight when people are here to comment on it, is that a change?
No, that's all set by ordinance, by the quorum court has that. So that this doesn't address any
Yeah,
of
that has nothing to do with it.
Okay, thank you.
Mm-hmm.
It looked like people were ready to leave, so I had to ask one more question. Hey, good evening. My name is Patricia, or I go by Trish Anslow. I'm at 14302 Goose Creek Road. I might be asking a little bit of a basic question. I couldn't find the maps very well online before I got here, but see them up there now. Is there any like a summary of comparison where you were in the zones previously and what the changes are proposed, like by acreage, by type?
No, we don't have like a comparison sheet to give you on that. I'll tell you the main changes here, like I said, most of this is exactly as it currently stands in our code.
The zones themselves?
The zoning part, that section 7, the zoning, that is the new part that we're adding. That is all new.
Okay.
And so that's the part that is really the change. The rest of it, everything else is for the most part exactly as it is written now.
Okay, thanks. And I'm trying to get an idea of, like, was something previously residential, now it's becoming industrial? Was something previously commercial, now it's becoming residential? Because it sounds like you're building a master plan, which is great, you know, kind of have a better idea.
Those only changes are there along those corridors. We would go ahead and changing those to commercial uses. It won't change our commercial zones. It won't change the use. Won't change. I've had a lot of people asking about taxes. Doesn't change your taxes at all.
Right.
But what that does is that says, hey, you can build a commercial property. We don't have industrial zones. They're based on some non-conforming uses that were grandfathered, or some that have received CUPs since zoning was adopted in 2006. There are some industrial properties that will be included as industrial. But there won't be like a zone for other industrial to go. Those are going to have to and those are going to have to be considered one by one by the quorum court every single time somebody wants to do one of those.
Okay.
But nothing else will really change, other than if there's a current CUP, we'll go ahead and zone that as a commercial property in the new map to show that because that's already been approved.
Okay. I'm also trying to get a sense of the change to know if any broader analysis was done. As an example, you guys passed the ordinance back in January to try to get after flood prevention, which was excellent. Got Goose Creek that runs through there, Illinois Bio runs through Washington County. Turning something from residential to commercial has the potential, not necessarily, but has the potential, and you cannot predict the future, of losing a lot of trees. That loses your ability to suck up that moisture, and it's going to head right to the creek. We've seen increase in flooding along those creek beds.
Well,
just trying to get a sense of that.
We don't measure flooding by like how many acreages. So when we do the floodplain, that floodplain ordinance like that was like passed based on like too many things. One of them, it's a FEMA federal requirements. The map has changed. It took them more than 15 years to change.
Yeah.
They normally hire multiple companies with the Corps of Engineers. They go and measure and do their own statistics. And lots of places I've seen, they shrunk, and some other places it expanded. So what most people come to us and says hey, now my lenders require me to have extra, for instance, insurance, and I have to pay more. That's not our requirement. We have nothing to do with it. We are not an insurance agency. That has to do with the federal government. So my answer is always to them according to what we've been advised. So if you've never had flooding in 20 plus years, just go and buy the cheapest annual and with the highest deductible, because you've never seen any. But that has nothing to do with what we do right now when it comes to zoning. Anyone wants to build anything in that flood area, by federal regulation, they have to apply for a permit, and they have to meet the standards of the states and the federal government.
Correct.
So which is now building above the BLE or the BFE, the flood-based elevation, a minimum of 2 feet, or you can flood proof everything.
Right.
That is too much to handle right now, but has nothing to do with zoning.
So what I'm trying to get at, though, is that you're talking about the very specific spot. So 15 years goes by, now I'm in a flood zone.
Yep.
What I'm talking about is the cumulative effects of all that master planning around that that just changed the zone, that one little point on the ground. So how did we analyze these potential zoning changes and look at environmental impacts, floodplain impacts, economic impacts?
We did not look at those. We looked at the most likely place for commercial growth as time has gone on. You look at the history of cities, and you look at the history of counties that have grown, and those commercial growths typically take place along those major corridors. That's where people go first. It's where people expect to go. And so our thought was we've got to have a place to move that to. And so we went ahead, we're looking to go ahead and zone that. Now, as it relates to the flooding and how that affects the tributaries and the creeks, we still have an engineering firm that looks at all of that and has to look at all that information to see kind of what it can handle, what it's got now, and then what has to be done to retain some of that to keep it from happening. We'll continue that process. Okay. That's still going to happen, and we're still going to take that into consideration.
Sure. I mean, in order to stay in the insurance program, you have to keep up with all that. I understand that. But the road structure, I'm just trying to get a sense of when you set these new zones in place, did you take a master plan approach, look at all the cumulative impacts, economic, engineering, environmental, and say this is the right zone? It sounded like maybe not. Maybe you just went with, well, it's going to happen anyway, so let me kind of put this map.
We don't have, the majority of what we get are these smaller commercial projects out in the county. We're not seeing a lot of really big projects in the county for good reason. You don't have really, like you said, the infrastructure, water, sewer, that sort of thing. But in trying to, without having to go through some big process to look at every single property, the infrastructure on the major corridors with water and with roads are better than out in the county. So if we can funnel that into those places where the roads are better and more equipped to handle that, we did take stuff like that into consideration. Sure.
Okay.
Yeah, as I mentioned now, we have 14 projects for this cycle, half of them on 412. So.
Okay. Yeah, if you have something, I'd love to be able to read it, just kind of see how you were thinking through things, because I call it the daily Weddington wreck. The infrastructure down there, it's tight, man, and the volume is really tight. And as we grow west, out in Washington County, it's only going to get worse. So I just wanted to see if you're putting a big approach to this, kind of thinking through all the consequences.
To the extent that we can, absolutely.
Yeah. Okay. Thank you.
Thank you. I want to thank everybody for coming out. If you have any questions as you look at this, we want to encourage people to reach out to our planning department. They'll be happy to take a look at it, take your considerations and questions. We will then we're gonna look at that, and then we'll have this to put back on the Quorum Court's agenda for their September meeting. So that'll be the first time it happens. I don't see this. This is probably not one of those things that should happen real quickly. And so there will be more time for people to provide any comment they may have. So thank you all so much.